Welcome to the 10th Justice Krishna Memorial Law Lecture, organized under the auspices of Sharada Krishna Sadgamaya Foundation for Law and Justice. May I invite the Honorable dignitaries onto the dais. I invite Honorable Mr. Justice Rohinton Nariman, Honorable Mr. Justice Nitin Jamdar, Honorable Mr. Justice E.K. Jayashankaran Nambiar, Honorable Mr. Justice K. Balakrishnan Nair, and Advocate Sanand Ramakrishnan onto the dais. Let's begin the ceremony by lighting the ceremonial lamp. May I invite the honorable dignitaries to light the ceremonial lamp and mark the official inauguration of the ceremony. I invite the honorable dignitaries to light the ceremonial lamp and mark the official inauguration of the ceremony. I invite Advocate Fatima Mohan for the prayer song. Kindly raise for the occasion.
കൽവിളക്കുകൾ കൈക്കൊടന്നയിൽ നീത്തിരി താലമേന്തി ഇടമാർന്നുണരുന്നു ഇവിടെ ഈ വിശ്വപ്രപഞ്ചത്തിലുയരുന്നു പ്രാർത്ഥന മന്ത്രങ്ങൾ സഹസ്രനാമങ്ങളാൽ കീർത്തനം പാടുവാൻ വിശുദ്ധ സ്നേഹത്തിൻ ശീലുകൾ മീട്ടാൻ അക്ഷയജ്ഞാനത്തെ സ്വന്തമാക്കുവാൻ പൊരുൾ തേടിയലയുമീ ഞങ്ങളെ എന്നും അക്ഷയജ്ഞാനത്തെ സ്വന്തമാക്കുവാൻ പൊരുൾ തേടിയലയുമീ ഞങ്ങളെ എന്നും നീ നയിച്ചാലും ദിവ്യഗുരു ഞങ്ങൾക്കെന്നും നീ മാത്രം കൽവിളക്കുകൾ കൈക്കൊടന്നയിൽ നീത്തിരി താലമേന്തി ഇടമാർന്നുണരുന്നു ഇവിടെ ഈ വിശ്വപ്രപഞ്ചത്തിലുയരുന്നു പ്രാർത്ഥന മന്ത്രങ്ങൾ പ്രാർത്ഥന മന്ത്രങ്ങൾ പ്രാർത്ഥന മന്ത്രങ്ങൾ പ്രാർത്ഥന മന്ത്രങ്ങൾ.
I invite Honorable Mr. Justice K. Balakrishnan Nair, President, Sharada Krishna Sadgamaya Foundation for Law and Justice for the welcome address.
Good evening to all. Distinguished guests on the dais, Honorable the Chief Justice of the Kerala High Court, Mr. Justice Nidin Jamdar, Honorable Mr. Justice Rohinton Nariman, Honorable Mr. Justice A.K. Jayashankar Nambiar, Advocate Mr. Sanand Ramakrishnan, who is the Secretary of Sharada Krishna Sadgamaya Foundation, which is organizing this function, esteemed members of the legal fraternity, including sitting and former judges of this court, senior advocates, retired judicial officers and staff of this court, dear students and their family members. It is my privilege to welcome all of you to this year's Justice V.R. Krishna Memorial Lecture, a prestigious event that celebrates the legacy of one of India's most revered jurists. Today, on this August occasion, we are paying our tributes to the remarkable contributions of Justice V.R. Krishna Iyer, a champion of social justice and human rights. His unwavering commitment to upholding the Constitution and promoting the welfare of the marginalized has inspired generations of lawyers, judges, and social activists. We are very much grateful to have Honorable Mr. Justice Nidin Jamdar, Honorable the Chief Justice of the Kerala High Court, for presiding over this function. Your presence adds immense value to this occasion. During this short span as the Chief Justice of this court, you have earned a reputation that you are a very learned judge who discharges his functions without fear or favor. You are very patient, courteous to the bar, but very strict while dealing with legal principles. We are really proud to have such a Chief Justice for our High Court. On behalf of SKS Foundation and all those assembled here to attend this function, I warmly welcome you, my Lord, to be the President of this meeting. We are deeply honored to have with us today Honorable Mr. Justice Nariman, who will deliver the lecture on the thought-provoking topic, Economic Criterion and Subclassification of Scheduled Castes. Has reservation eclipse merit altogether? This topic is particularly relevant in today's context. We look forward to Justice Nariman's insightful analysis. Mr. Justice Rohinton Nariman is a distinguished jurist and a leading voice on constitutional law and human rights. His erudite judgments and scholarly writings have significantly enriched our understanding of the law and its application in contemporary society. We are confident that Justice Nariman's lecture will stimulate thought-provoking discussions, challenge our assumptions, and inspire us to work towards creating a more just and equitable society. I extend a warm welcome to you, my Lord, as the main speaker of this function on behalf of SKS Foundation and all those present here. We greatly appreciate Honorable Mr. Justice A.K. Jayashankar Nambiar's participation in making the commemoration address. Your reflections on Justice Krishna Iyer's life and legacy will undoubtedly enrich our understanding of his contributions to Indian jurisprudence. We welcome you wholeheartedly to this function on behalf of SKS Foundation and all those present here. I extend my warm welcome to all distinguished guests present here, including the former sitting and former judges, senior advocates, retired judicial officers and staff of this court, members of the public, the law students, some of whom are here to receive awards instituted in the name of Justice V.R. Krishna Iyer, and the family members of them. I also warmly welcome the
Jamda, Chief Justice, High Court of Kerala, for the presidential address.
Justice Rohinton Nariman, former Judge of Supreme Court of India, Brother Justice Nambia, Justice Balkrishnan Nair, President of the Foundation, my sister and brother judges, former Judge of the Supreme Court of India, Justice Joseph, former judges of the High Court, law officers of the central and state government, office bearers of this foundation, judicial officers, senior advocates, and all my friends. A very good evening to all of you. Today's function is to pay tribute to late Justice V.R. Krishna Iyer. It would be an understatement to say that Justice Krishna Iyer was an intellectual giant on our legal landscape. His extraordinary intellect can be seen through his judgments, writings, articles, speeches, and even poetry. Over a remarkably long career, he has left a mark on our society through all his roles as an advocate, a legislator, minister, judge of the High Court, judge of the Supreme Court, member of the Law Commission, author, poet, and a social reformer. Today's speaker, Justice Nariman, has also made significant contribution to Indian jurisprudence through his judgments reflecting his sharp legal acumen and deep understanding of constitutional principles. And Justice Nariman's eloquence and scholarly approach can be seen through his judgments spanned across diverse fields in law. And therefore it is befitting that for this 10th Justice Krishna Iyer Memorial Lecture, the Foundation has invited Justice Nariman. He shares the same passionate commitment to justice and the rule of law as Justice Krishna Iyer. I am told that one more highlight of today's function is the merit awards to the first rank holders of LLM and LLB programs from various universities in Kerala. Congratulations are due to all rank holders and their proud parents. The topic for the 10th Justice V.R. Krishna Iyer Memorial Lecture is an important one, that is economic criteria and subclassification of scheduled caste has reservation eclipse merit altogether. This topic holds a particular relevance today as we grapple with balancing the principles of equality and merit in a diverse and dynamic democracy. This debate lies at the core of our commitment to justice, equality, and progress. The question that is often debated is whether reservations, originally conceived as a tool to uplift historically marginalized communities, should be recalibrated to account for economic factors or intra-community disparities. Justice Krishna Iyer, who was known for his profound commitment to social justice and human rights, would have asked the very same question: are the benefits of the system reaching to those who need them most? And we are fortunate to have Justice Nariman to expound on this question. I am sure Justice Nariman will explore this intricate issue with his insights He will enrich us in complexities of law and societal progress. Like all of you, I am also eagerly awaiting to hear his speech, so I will not stand anymore in the way. I thank the office bearers for giving me this opportunity, and again congratulate all the rank holders. Thank you very much.
Honorable Mr. Justice Rohinton Nariman, former Judge, Supreme Court of India. An illustrious litigation career spanning 35 years, with the exceptional accomplishment of designation as a senior counsel at the age of 37, and over 500 reported Supreme Court judgments to his credit. His expertise in comparative constitutional law and civil law is unparalleled. With over 300 judgments, his tenure as Judge of the Apex Court reflects his legal acumen, erudition, and profound commitment to social justice. It's a privilege to welcome Honorable Mr. Justice Rohinton Nariman to deliver the 10th Justice V.R. Krishna Memorial Lecture on the topic Economic Criterion and Subclassification of Scheduled Caste. Has reservation eclipsed merit altogether? Welcome, sir.
Honorable Chief Justice, Justice Balkrishnan Iyer, Honorable Judges of the High Court, my dear brother K.M. Joseph, dignitaries on and off the dais, ladies and gentlemen. Today's subject evokes strong feelings. I have in fact chosen the subject myself in order to discover whether two recent Constitution bench judgments are correct in the perspective in which they were decided. Incidentally, both of them yielded dissents. The first judgment dealing with the 103rd Amendment, which introduced the economic criteria as a basis for reservation, has a dissent by Justice Ravinder Bhatt, joined by Chief Justice Lalit. And the second judgment, which is State of Punjab versus Davinder Singh, is a 7-judge bench, which was tasked with looking into whether an earlier Constitution bench judgment in E.V. Chinnaya's case was correct. And that judgment deals with whether you can further subclassify scheduled castes into groups so that ultimately those who are most deserving among them alone get the benefits of reservation. And here again, we have one dissenting voice, that of Justice Trivedi. To begin at the beginning, when our Constitution first came into force, it had to grapple with social inequalities of a different order altogether. We had in our society persons who were called depressed classes by the British, who were untouchables, who were actually outside the Varna system, and who were treated as serfs instead of as human beings. And our Constitution, therefore, had to do something to remedy this terrible social disorder. It chose a particular method which I don't think was chosen by any other written constitution till that date. Certainly not by the US Constitution, which also had centuries of slavery and servitude. So that ultimately our Constitution first chose the fact that there should be empowerment in the legislature. Now, in order to empower what was called scheduled castes and scheduled tribes, euphemistically, the President of India was to make a list of these depressed classes under Article 341 of the Constitution of India. And this list could then be amended, either added to, modified, detracted from, only by Parliament. The same went with the scheduled tribes under Article 342, because we also had a large number of tribals all over this country who perhaps were its very, very original inhabitants, who also were in great need of social upliftment and being brought into mainstream life and society. Now, once these lists were made, there were constituencies reserved for scheduled castes and scheduled tribes, both parliamentary and in the Vidhan Sabha of the states. And they were to follow the proportion that these persons had to the total population of the country. So that in Parliament and in the Vidhan Sabhas, by Articles 340 and 342, what was reserved for them was roughly 15% of the seats, of the total number of seats, and 7.5% of the total number of seats in the case of the scheduled tribes. The focus at the start of the Constitution was on, therefore, these scheduled castes and scheduled tribes. There was one other measure of upliftment which was envisaged, and that we find in Article 16, sub-Article 4, because government in this country is perhaps the largest employer of human beings. And as that large employer, therefore, reservations should take place in central and state government and other governments down the line employment of such persons, this time referred to no longer as scheduled caste and scheduled tribe, but as backward classes. And there was one caveat. That caveat was that this is, of course, provided that they were not adequately represented in the service. At that point of time, of course, they were not represented at all. So the question would arise in the future as to when to stop such reservation for such people. And of course, we had a directive principle of state policy in Article 46, which spoke of the weaker sections of society. So if you look at the Constitution as originally framed, you had three different expressions to describe essentially these people. The first expression was scheduled castes and scheduled tribes, which, as I told you, consisted essentially of those depressed classes who were treated as untouchables. Then you had a larger concentric circle which took in other backward classes. And incidentally, at the start, you had a backward classes commission which could have been appointed by the president by notification if it was so found necessary. And even though the word backward classes was not prefaced by socially and educationally in 16.4, it was so prefaced in Article 340, which is an important fact that has been missed by judgments down the line. So we have, therefore, these three concentric circles. We have the largest in Article 46, which speaks of the weaker sections of the people. Of course, the weaker sections of the people subsume scheduled castes and scheduled tribes, and also subsume others who are in need of social upliftment. This is very, very important to remember at the outset itself, because the article specifically speaks of these persons, the weaker sections, who have to be protected. Now, protected from what? First, from social injustice, and second, from all other forms of exploitation. So they are an exploited lot who have not seen social justice. One of the first cases that came up to our Supreme Court came from Madras, and it was a challenge to what was called the communal government order at that point of time, which was a roster of 14 persons and which would be followed for appointment both for district munsifs under Article 16 and for persons who gain admission in medical and engineering colleges. Champakam Doriyarajam was the judgment which dealt with medical and engineering colleges. And the roster went something like this. You had Harijans, you had 2 seats reserved for Harijans, you had 2 reserved for backward classes, you had 6 reserved for other Hindus, you had 2 reserved for Brahmins, and then you had 1 each reserved for Muslims and Christians. And it is this geo that came up for consideration. In this case and in the companion matter, Venkatraman versus the state, which dealt with the post of district munsif also on the basis of a communal geo along these lines. The Supreme Court had no problem in striking down this communal geo because according to the Supreme Court, this would violate directly the equality principle contained in 15.1, 16.1 and 2 and 29.2, which dealt with admissions to educational institutions, particularly aided institutions. And therefore, it was said that so far as this geo was concerned, it couldn't be followed. Under 15, of course, it couldn't be followed because there was no exception whatsoever. But under 16, it could have been followed by only 2 of the 6 categories. The 2 categories being the Harijan, which is the most depressed, and the other backward classes. But they said that's not good enough to sustain the geo, so the geo as a whole was therefore struck down. Now, close on the heels of these 2 judgments came the First Amendment. And the First Amendment now added a new Article 15.4, which dealt essentially with educational institutions, and spoke now of scheduled castes and tribes as one category, and socially and educationally backward persons as the second category. Now, socially and educationally was not introduced by the First Amendment. Don't forget, I told you, Article 340 in the original Constitution already had this expression. And all that was done was to borrow this expression and put it into Article 15.4. So that Article 15.4 was brought on par, so to speak, with Article 16.4. In the decades that followed, there were a number of matters which came up to the Supreme Court. For paucity of time, it's not possible to go through this case law, except to tell you that the important principle that was culled out by these cases was that 15.4 and 16.4 were in the nature of an exception to the general principle. This was particularly with regard to Article 335, where scheduled castes and tribes were concerned. Now, 335 specifically speaks of the claims that scheduled castes and tribes have upon the government to uplift them, which must be consistent with efficiency in administration. And this is where the merit principle therefore comes in. So it has to be a balancing act. And the early judgments balanced the right under 16.1 and 2 with the reservation policy under 16.4 by calling for an exception to 1 and 2. Now, there was only one voice in the wilderness, and it was a lone voice. And that was the voice of the great Justice Subbarao. And Justice Subbarao in Devdasan's case, which essentially was a carry forward of vacancies case, said that it is wrong to view Article 16.4 as something which is an exception to the main principle. It is in fact an amplification of the main principle itself. Because just as classification is a tool which is used to separate those who are completely different from each other, here the same tool is used and re-emphasized in 16.4. So that Justice Krishna, in fact, in a later judgment in the Akhil Bharatiya Associate Sangh case, called it a constitutionally sanctified classification, which is correct. So the shift, therefore, according to Justice Subbarao would have been, don't view this as an exception, but view this as part of the general rule itself with classification inbuilt. This vision finally gained fruition in Thomas's case, which is the famous judgment in 1976 of which Justice Krishna was also a part. And 4 out of the 7 judges there clearly held that it would appear that Justice Subbarao's vision of these articles would be the correct one and not the exception vision. By the way, the exception vision also had, in Balaji's case, as a result of the exception vision, a 50% cap that was put, because if 15(4) and 16(4) are supposed to be exceptions, obviously the exception can't eat into the rule, and 50% is giving a huge margin to the exception, so that you can extend reservations up to 50%, but no more. Now, all this became extremely contentious in the years that followed. There were a number of judgments. And we can go straight away to the 9-judge bench judgment in Indira Sawhney's case. Because Indira Sawhney's case dealt with 2 government orders which implemented what was called the Mandal Commission report. The Mandal Commission report of 1980 essentially wished to expand the category of have-nots exponentially. Because whereas you had scheduled tribes and scheduled castes as the first constitutional vision, now there was a separate vision which said, no, there are also other backwards who are like them. And that backward again eats into the general category, population-wise and proportion-wise, in a very huge way. So that whereas 15% and 7.5% used to be reserved, this huge additional chunk of 27% now came. And the government order, therefore, specifically said now there will be reservation on 2 criteria, and this is what is important to remember. One criteria will be pure economic, which is the subject matter of the first judgment I'm going to deal with. And one GO said 10% must be reserved for persons who are economically below what they call the poverty line, and they described it. The other was for backward classes, up to a maximum of 27%. And since there were differing strands of thought in all the judgments till that date, in 1992 there was this 9-judge bench convened, which now spoke with one voice, the voice being of Justice Jeevan Reddy. There were other voices also, but he spoke for 4 of them, and a 5th learned judge joined him, so that he became the majority in effect. Now, what did he hold? It's very important to know what he held to appreciate the classification of on the basis of economic criteria later. He first struck down the 10% GO, which said economic criteria alone. And he struck it down saying that our constitution did not envisage poverty alone as a criteria. Essentially, reservation had to occur only if there was social downtroddenness. And if that is accompanied with poverty, fine. If not, poverty itself is not something that is contemplated by the founding fathers at all. I will tell you for very good reason what he said is correct, but that will come a little later. So the first thing he did was to strike down this 10% on the ground of economic criterion alone. The second thing he said was that he now sanctioned the Subbarao vision in Devdas' case, and then said that this is the correct view of the law. And since we are 9 judges, we now overrule what the majority said. So that today it's now part of our constitutional scheme of things to say that 15(4) and 16(4) cannot be treated as exceptions. They are to be treated as part of the rule itself. And being part of the rule itself, it is constitutionally sanctified classification, and it also shows the extent to which you can go, which was what was Justice Matthew's view. So we have, therefore, this vision which is now part of the judgment of the court, so that 16(4) and 15(4) are now no longer exceptions. But we can't forget 335. Since we can't forget merit altogether, the 50% cap was introduced. And they said that, look, even though it may well be that you may make reservations under 15(4) and 16(4), you see that you do not go above 50%. The judgment did say there may be certain exceptional situations, but keep them apart. As a general rule, if you take a particular year as the unit which you have to see for the purpose of reservation, then in that year you cannot have more than 50%. So this was the second important proposition laid down. What was also laid down was that 15.4 and 16.4 use different language. And because they use different language, 16.4 was wider than 15.4. I respectfully demur. I don't think that's a correct way of viewing the Constitution, because the vital article that was missed was Article 340. And the earlier judgments were right on this score, because the earlier judgments all said that backward class, basically, in 16.4 meant the same thing as 15.4, which is that they should be both socially and educationally backward. However, this is not a point which requires much deliberation, because ultimately Justice Jeevan Reddy also accepted that the accent really would be on social backwardness. So when you're talking of the backwards under section Article 16.4, you are talking of social backwardness, essential. Again, poverty goes out, because it is social backwardness really, which are accompanied with poverty, which is what the basis of the article is. Justice Jeevan Reddy also then went on to say that 16.4 exhausts the gamut of special provisions that would therefore be made in favor of the scheduled caste, tribes, backwards, etc. If other provisions have to be made, they have to be made in strictly exceptional circumstances under the main article. So despite accepting Justice Subbarao's view, the 50% cap was introduced, and 16.1 was not given the free rein that was given by the earlier judges. It was 16.4 which was the focus, and not 1. Of course, he went on to say, one must exclude what is called the creamy layer. Now, the creamy layer is a beautiful metaphor coined by Justice Krishna Iyer in the Akhil Bharatiya Soshit Sangh case, because it tells you exactly what a glass of milk is with and without the creamy layer. You must get rid of the creamy layer who has already availed the benefits of reservation to make way for those who have to drink the milk now. So creamy layer was an important concept introduced, of course, to backward classes. Because don't forget, Indra Sawhney's case was not concerned with scheduled castes and scheduled tribes. It was concerned only with backward classes. He also went on to say that you could further subclassify backward into more backward and backward, because the idea is really to get to those who are the real have-nots. What Justice Krishna called the Harijans among the Harijans. So the idea was really to get to those who are at the bottom of the barrel and who have never tasted the benefits of reservation, even though at that point of time 50 years had gone, 60 years had gone since the Constitution was promulgated. Another important rule that he laid down was that you give an initial leg up but no further. So therefore he accepted the principle of the minority judgment in Rangachari's case, where they said that once the first leg is given into a particular service or post, thereafter there is to be no relaxation when it comes to promotion. If you are to be promoted, you get promoted along with everybody else and you follow merit like everybody else. Now, given all these things, and of course one more very important thing, which is that as you go further up and you get to super speciality posts, there will be many areas in which there should be no reservation at all. Now, having laid all this down in 1992, once and for all we thought that our law was completely settled. That was not to be so. But at the same time, many people are under the misconception that large parts of Indra Sawhney were done away with. On the contrary, large parts of Indra Sawhney were sought to be actually implemented by constitutional amendments. And now let me tell you what happened thereafter. As I told you, it was a 1992 judgment. The first amendment that comes is the 77th Amendment in 1995. And that introduces an Article 16.4 capital A. Now, what is very important is that this 16(4) capital A speaks of reservations in promotion, but strictly confined to scheduled castes and scheduled tribes. So far as backwards are concerned, reservation, there will be no reservation in promotion. So Justice Jeevan Reddy's judgment actually followed. It's only made clear in 16(4)A that so far as the further leg up is concerned, that will apply only to scheduled castes and tribes and not beyond, not to backwards. 16(4)B was again introduced by yet another constitutional amendment, the 81st. And that amendment is extremely important because though it deals with carry forward alone, what it did was to constitutionally sanctify the 50% cap. Because what it said was that when you have carry forward in vacancies, you will treat those vacancies apart from the other vacancies, to which the 50% cap will not apply. So instead of doing away with what Justice Jeevan Reddy said, it in fact constitutionally sanctified exactly what Justice Jeevan Reddy said. And it also spoke of the year as being the unit. So Indra Sawhney was actually followed in 4B. In one sense, it was done away with, which is to introduce a proviso to Article 335, which spoke of efficiency in administration. And when Indra Sawhney had said that we will not allow you, once there is a promotion, to relax any standards, they said, no, we are adding a proviso. And by that amendment, the proviso said you may relax standards so far as promotion is concerned. Again, only qua scheduled castes and tribes. So even though Justice Jeevan Reddy's judgment may have been done away with in part, it is only qua scheduled castes and tribes, not qua other backward classes. This is important to appreciate. Now, with this constitution, this background, the stage is now set to examine the 103rd Amendment with which we are directly concerned. The 103rd Amendment introduced a new Article 15(6) and an Article 16(6), in which it said for the first time that the state may reserve up to 10%. It didn't have to reserve 10%. Incidentally, every one of these articles is enabling in the sense that you don't have to exercise the power given to you. Unlike what is given to the scheduled castes and tribes, qua Parliament and the legislative assemblies. So you may up to 10% reserve so far as educational institutions are concerned in 15(5) and 15(6), and so far as posts under the government in 16(6) are concerned. And it is this amendment that came up before a constitution bench in the Janhit Abhiyan versus Union of India case. Now, as I told you, there were 5 learned judges, 2 of whom dissented. Each one of the majority judges wrote a separate judgment. The sum total of that judgment is that even though the 103rd Amendment specifically spoke of the Article 46 as being the springboard for that amendment, namely that according to Parliament, it is Article 46 which mandated reservation based on the economic criteria. Each one of them said that the economic criteria can be a matter for classification by a constitutional amendment as opposed to what was said in Indra Sawhney's case. So Indra Sawhney, 9 judges did not bind them because they said that when you speak of Articles 15(4) and 16(4), the position is entirely different. Because there you are speaking of persons who are socially and educationally backward, whereas here, Parliament is creating a new category for the first time. And that it is entitled to do following Article 46. Justice Bhatt differed. And Justice Bhatt said that yes, I agree with you that Parliament is so empowered, but I would strike down the amendment because the amendment says that this 10% economic criteria will apply to persons other than those for whom reservations have already been made. That is, other than scheduled castes and tribes other than backward classes. So he said that if you are not going to take into account the most economically deprived members of society, saying that these members of society have already been provided for, there would be an egregious violation of the equality principle contained in the main parts of 15 and 16. That is 15.1 and 16.1 and 2. And he would therefore strike it down on that ground. He said nothing about the 50% cap except to utter a note of caution, saying that it's pending in some other case. The majority, however, went on to say that Indra Sawhney's case did not say that 50% had to be there invariably. No. 50% with exceptions is what Indra Sawhney itself said. So therefore, something more than 50% is allowed. Now, first and foremost, 50% is constitutionally sanctified was missed by every member of the court. Everyone missed 16(4)(b). Because 50% is now recognized in the Constitution. It's no longer a matter of looking at Indra Sawhney. It's a matter now of constitutional principle. And therefore, if you missed this extremely important provision, the entire judgment is rendered in that sense per incurium. So, the 50% cap which is constitutionally sanctified has to be adhered to. What they could have held, of course, was that given 50%, because don't forget, 16.6 and 16.4b have to be harmonized. 4b lays down the cap, 16.6 gives 10% more. Now it's up to 10% more. So that when you have up to 15% for scheduled castes, 7.5% for scheduled tribes, 27% for OBCs, you've already reached the figure of 49%. And if you're going to add 10 more, you reach 59%. So the correct way of harmonizing the two articles would have been that you stick to 50%, but you can reduce something within the OBCs so as to fit in, let's say not 10%, but something down the line of 5%, 6%, 7%, so far as the economic people are concerned. But I now come to the very basis of the judgment. According to me, Article 46 does not at all sanctify a classification based on economic criteria. A simple reading of the article itself will show you that, because the last part again is completely missed by all 5 learned judges. 46 begins by saying that it shall be the duty of the state shall protect. And basically what the state shall do is to promote the interests of, which are, and by the way, the interests are stated to be educational and economic. So the state shall promote the educational and economic interests of the weaker sections of the people, in particular the scheduled castes and tribes, so as to protect them from social injustice and all forms of exploitation. If you read the article as a whole, there can be no doubt whatsoever that the weaker sections spoken of in the article are those who require to be protected against social injustice and all forms of exploitation. Now, what you have actually achieved is to do exactly the contrary of what Article 46 tells you to do. Though the statement of objects and reasons of the 103rd Constitution Amendment Bill was that we are doing this in pursuance of 46. What you have achieved by the amendment is nothing short of turning the Constitution on its head. Why do I say so? First, you exclude all those who require to be included. So you exclude scheduled castes, scheduled tribes, backwards. Having excluded them, who do you include? This is most important, not looked at. You are only including upper castes. If you keep all these people away, who do you include? You only include Brahmins, Kshatriyas, Vaishyas. And also Muslims and Christians. Now this becomes a huge problem, because when you include these people, the founding fathers would say that there's no question of any reservation except because there has been historical wrongs done. where persons have never suffered from these wrongs, you are now reserving something for. And where historical wrongs have been suffered, you are not reserving things for. So actually the constitution now is turned on its head. And Muslims and Christians, don't forget, the presidential list of scheduled castes under Article 341 specifically said it was only for Hindus. You could not have Muslims and Christians in it. And therefore, the founding fathers said, since there's to be no reservation for these two categories, we will give you another right which people don't have, Article 30. And Article 30 is the right which is given to minorities to establish and administer institutions of their choice. Now, all this is given a complete go-by. And we find that there is an amendment now which has turned the constitution on its head, which is now completely sanctified by these three learned judges. Justice Bhatt also, in one other segment of his judgment, says that there's an additional reason why 16.6 would be bad. 16.6 does not have what 16.4 and 4a have, namely, that everything has to be posited on adequacy of representation in the service. Now, there is no adequacy of representation in the service under 16.6 when it comes to economic criteria. And if that is so, then all sorts of upper caste people will come in via this back door who are adequately represented in the services. But he didn't go the logical step further to say that this won't apply only to 16.6, it applies down the board to the entire amendment. And the entire amendment would be bad because, as I said earlier, you are keeping the have-nots out and you are putting in only those for whom reservation was never meant. Whether it be Brahmin, you're in fact back to Champakam Dorya, the communal geo. So, in my respectful submission, this is a rare case of both majority and minority being in error when it comes to the very concept of an economic reservation. Now we come to one other very interesting aspect. Don't forget, this is a constitutional amendment. So to strike it down, you have to apply the basic structure doctrine. The majority judgments, two of them, explicitly chose the Krishna-Iyer approach. Now, what do I mean by the Krishna-Iyer approach? To tell you about this approach, let's backtrack a little. You have Keshavananda Bharati's case, which every one of you in this hall knows about. You have, by that razor-thin majority of 7-6, the basic structure doctrine laid down for the first time in 1973, by which you could substantively, apart from procedurally, attack a constitutional amendment. There were 6 dissenters. But interestingly, even the dissenters, 4 of them, which included my brother's father, Justice Matthew, would all, 7 of them struck down the last part of Article 31C. But even these 4 say that the last part of 31C cannot exist. Now, what do I mean? 31C was one of the articles which was introduced, which gave primacy to 2 directive principles over various fundamental rights. And the last part said that the moment there is a law made pursuant to these particular directive principles, they are shielded from an attack on the ground that fundamental rights are violated. But if the law contains a declaration and says that I, the legislature, have examined for myself that this law is in pursuance of those directive principles, the court cannot go into that. The court is shut out even from the limited judicial review of finding for itself whether that legislation is or is not in pursuance of those 2 directive principles. 7 of them applied the basic structure theory to void that provision, limited to that provision. 4 of them said that provision cannot obtain but didn't give reasons why. This is what is amazing. Because 6 of them held there is nothing like basic structure. And if there's nothing like basic structure, a part of a constitutional amendment cannot be struck down, ever, on substantive grounds. So this is one little conundrum that very few people know. And of course, immediately after 1973, when 4 dissenters had to apply the law, they applied it to the 39th Amendment to strike it down, applying basic structure. Something like my very first judgment in the Supreme Court, I must tell you. I sat in a constitution bench immediately. In fact, my very first address as a lawyer to the Supreme Court was to a constitution bench, which is in the reported case of Prakash Amichand Shah. It's a 1985 judgment. So I sat in Muhammad Arif's, the bench which decided Muhammad Arif's case, in order to say that when there is a death sentence, a review which is normally not heard in open court should be heard in open court, because after all, a man's life is at stake. And you give him this opportunity and limit it to half an hour and nothing beyond, since it's a review. Justice Chelameshwar dissented, said no. Within a year of the application of my judgment, Justice Chelameshwar himself commuted a death sentence when sitting in review to life. Now this is exactly what happened so far as Keshavan, the Bharati's minority is concerned. And then of course we come to the famous trilogy of judgments. Minerva Mills, followed by Bhim Singh Ji, which is a remarkable judgment, followed by Vaman Rao. Now, each of these judgments also applied basic structure to void various articles. But the Krishna-Iyer approach is what we find in Bhim Singh Ji judgment. What did Bhim Singh Ji entail? It entailed a challenge to the Urban Land Sealing Act being put into the 9th schedule and hence immunized from attack because of the operation of Article 31, capital B. All 5 judges were agreed that one particular section, in fact I may call it a reasonably innocuous section and a property section, 27(1) of the Urban Land Sealing Act, was constitutionally infirm. What did the section say? The section said that if there is urban land with a building on it inside an urban area, then the owner cannot transfer, meaning cannot sell, mortgage, rent, do anything with the land for a period of 10 years without the permission of the competent authority. The 3 learned judges, that is Chief Justice Chandrachud, one other learned judge and Justice Krishna Iyer, all agreed that this section is bad. They didn't give reasons. So we are left guessing as to what the reasons were. So far as the minority judges are concerned, they gave reasons. Justice Tuljapurkar saying it violates Article 14, which is part of basic structure. And Justice A.P. Sen saying it violates 19(1)(f) and 31, which are properties articles, which are also part of basic structure. But Justice Krishna Iyer's judgment, apart from saying I agree that 27(1) must be struck down, laid down a principle. And the principle was that a basic structure violation can occur only if, in his words, there is some egregious, that is very, very intense, shaking of the Constitution, in the sense that there is an intense or egregious violation of the egalitarian principle, which is some principle hovering over the articles of the Constitution. Now, Coelho's case, which is a judgment of 9 judges much later in 2007, specifically said that you cannot found basic structure in the sky. It has to be terrestrial. So it has to be the egalitarian principle contained in Article 14, 15, 16, or whatever it was. So to this extent, the Krishna Iyer test is not agreed to and is out. Yet, we find the majority, 2 judgments, directly applying the Krishna Iyer test, which is the wrong test to apply straight away. The 3rd learned judge, Justice Pardiwala, applied the Grand Rock Estates test, which is more or less the Krishna Iyer test. So you may take it all 3, applied the Krishna Iyer test. So far as the minority is concerned, Justice Bhatt did us a great favor by saying that after Coelho, the Krishna test cannot be applied. And then went on to say that the correct test is what is the impact of the amendment on the Constitution. Does it change the Constitution? And then went on to add that change means does it damage the Constitution in any way? Because otherwise, 27(1) cannot be explained. You can't explain how 27(1) was struck down. And nobody later has said that that was a wrong decision. So we have major problems, therefore, with the majority, even on the score of how they view a constitutional amendment and how it is to be struck down. So in my respectful submission, this economic criteria judgment is not correct either in constitutional law or in principle of any kind. As I told you, it is in fact in the teeth of Article 46 and certainly in the teeth of 15(1) and 16(1) as rightly held by the minority judge, Justice Bhatt. We now move on to the second judgment. That again raises a very contentious and interesting issue. You remember I told you that under Article 341 and 2, the President makes a list of scheduled castes and scheduled tribes. That list can be tinkered with, modified, added to, subtracted from, only by Parliament. So Chinnaiya's case held, in a case which came up from Andhra Pradesh, that the bifurcation of scheduled castes into groups, saying that you, Group A, seem to have got a lot more than Group B. So therefore, within the 15% that all of you can have, your share in the cake or pie now should be reduced to 1%. Group B can get, let us say, 5%. Group C can get a little more because it seems to be at the bottom of the barrel. And Group D can get 2%. Now, is that constitutionally valid or is it not valid? Chinnaiya, 5-judge bench said no. Because the moment you, the state, says that scheduled caste X will get a certain part of the pie and you, scheduled caste Y, will get a lesser amount or no amount of the pie, you are directly tinkering with the list which Parliament alone can do. The majority judgment correctly held, in my opinion, that you don't tinker with the list at all. And the distinction really between the list and the reservation provisions is brought out in the concurring judgment of Justice Gavai. Because the Chief Justice and one other learned judge delivered the main judgment. Justice Gavai concurred and then various other judges went on to agree with both of them, except for Justice Trivedi, who dissented. Now, Justice Gavai made the vital distinction between a list being drawn up and reservations being made. A list is drawn up under 341. Reservations are not made under 341. Reservations are made only under 15(4), 16(4) and the like. So, the moment the list is drawn up and somebody is either one person or one caste in that list is either dropped from a reservation policy or restricted within that reservation policy, you are not tinkering with the list remains as it is. All that you are doing is, you are saying, given based on data, that we find that these people are adequately represented in the service, they don't require it. But unfortunately, the learned judge doesn't follow it to its logical conclusion. Because he agrees with the learned Chief Justice when the Chief Justice says that so long as you do not exclude any one of them from reservation, it is all right. In my respectful submission, wouldn't make the least difference. Because you are not touching the list. And I'll give you a simple example to bring the point home. You have these scheduled caste, scheduled tribe and backward classes permanent national commissions under our constitution. Each commission is to look into how the scheduled caste, tribe, etc. has fared in terms of the reservation policy working on the ground. Now take it that one particular report given to the President let's say of the Scheduled Caste Commission, says that Scheduled Caste X, Y, A, B, C have all been equalized now and deserve to be dropped from the list. And this table, this report reaches the government. The government in its own time acts on it, say 2 years later. What happens in that interregnum for 2 years? Does the state have to go on giving reservations to persons who have now reached the limit and who actually have availed of these reservations? Or can it say, no, I'm not giving it to them, I'm giving it to persons who are more deserving? The answer is obvious. So I wish they had grounded this in Justice Gawai's argument, which was not taken to its logical conclusion, that the two, that is the making of the list and the reservation, are entirely separate. And ne'er the twain shall meet. One other interesting feature of this case is that the Chief Justice speaks of Article 335. Now, Justice Krishna Iyer in all his judgments, whether it's in Thomas, Akhil Bharatiya Social Sun, etc., makes it clear that reservation is to be consistently with 335. He always says so. And 335 has two facets. The first facet is to say that, look, it is important that these people are uplifted. And the second facet is to say, yes, but that should not mar or compromise efficiency of administration. The Chief Justice in this judgment says, forget the second part, in essence. The first part is only an emphatic remembrance that we have to uplift these people. My respectful submission, that's also not correct. And now we come to the very vexed question of, should these reservations go on forever? There are so many different responses. In KC Vasant Kumar, for example, Chief Justice Chandrachud said that, look, we are now so many years after the Constitution. 50 years after the Constitution, you should apply a means test, economic criterion test, to weed out those who are now done well in terms of income. And maybe you should have a review every 5 years. Justice D.A. Desai also said pretty much the same thing, but added that at some point of time they have to come to an end. And at that point you must say, now, thus far and no further. Equally, in the first judgment that I was referring to, the economic criteria judgment, both Justices Trivedi and Pardiwala expressed their reservations along these lines. And Justice Trivedi said, look, just as so far as Parliament and the Vidhan Sabhas are concerned, you have a 10-year period which keeps getting extended. You should have the same kind of period so far as 15-4 and 16-4 are concerned. So she advocated a time at which everything comes to an end. Justice Pardiwala said that you shouldn't take into account these reservations continuously because then they become vested interests. And on that ground also you should try and weed out those who have already had enough of the pie so that others may come in. But that doesn't tell us what happens ultimately. At which point does the entire thing stop? In the second judgment, Justice Mittal, in a very short judgment, says that why don't we have this concept, at least so far as Article 16 is concerned, that the moment there is a person who has availed of Article 16(4), in that he has been appointed to a particular government post, his generation now is availed of it, the next generation can't. So there are various ways of looking at this. I would, after a lot of reflection, say that it's very difficult to apply the hammer like this at any point of time. We have these national commissions, one to look after scheduled castes, one for the tribes, one for the backwards. They have to submit reports every year. Now, it is only when they submit a report saying that, let us say, backward class X along with A and B, or scheduled caste X along with A and B, seem to have availed enough in terms of the reservation, and therefore they seem to have joined the mainstream. So slowly start deleting them from these lists. and which will therefore be a process where the reservation now tapers down, number one, to those who deserve it, and then slowly, when everybody has reached a certain level, goes out. But it's a slow process. So according to me, this is a vexed question. I wouldn't advocate a time limit. What I would say is that there should be a periodic review, such as was suggested by Chief Justice Chandrachud. And after that periodic review, slowly and steadily, if the policy is working, one must make it shrink so that ultimately, at some point of time in the conceivable future, not only will the percentages come down, because the moment it shrinks, your 27% will become 22, which will become 15, which will become 10, slowly. And finally, they will disappear. So, to end this huge dissertation on these two judgments, I honestly feel that reservation chosen by our founding fathers was absolutely correct and was the felt need of the day. There's no doubt that even after so many years have passed, 75 have passed, the policy has not worked as was envisaged. So I would only suggest that the commissions be empowered with ground staff, field staff, to see that these reservations are meant to alleviate what they are supposed to alleviate, after which finally, like old soldiers, the entire thing will vanish away. Thank you all very much.
Thank you, sir, for that insightful and enlightening address. I invite Honorable Mr.
Justice K.M. Joseph, ladies and gentlemen. First up, let me confess to being absolutely mesmerized and awestruck these past 30 minutes or so by the sheer depth of knowledge that one finds in Justice Nariman. I say this because it's always a problem when you get up to speak after Justice Nariman has spoken. Because for some reason you're paying so much attention to what he's saying, and that when it comes to your turn, you're standing up here and wondering why you're standing here in the first place. I personally feel that there cannot be a greater tribute paid to late Justice V.R. Krishna Iyer, in whose memory we are actually holding this function. So thank you, Justice Nariman, for your wonderful, wonderful exposition of the law of reservation. Justice Vaidyanathapuram Ramakrishna Iyer, Justice V.R. Krishna Iyer. He earned for himself the sobriquet of Bhishmacharya of the Indian judiciary. And of him, much has been spoken both while he was alive and since his passing. That I personally feel that whatever I say today will be nothing more than verbal surplusage if I were to go into his achievements as a jurist and a renowned jurist of our country. So I thought about it for some time, and the time allotted to me is about 5 minutes. And 5 minutes is too little a time to talk about Justice Krishna's achievements in the legal arena. So I thought I would just share with you some of my perspectives, my own little perspective of the legend that was. I knew Justice Krishna Iyer from the time when I was a school kid. He began his practice in Telisheri, where my maternal grandfather also began his practice. And therefore the families were very close. And during the final years of his life, there was not a day that passed without Justice Krishna Iyer coming home in the evening. He would come home for a cup of tea, and this would be invariably either before he was going for the walk or coming back after the walk from Darbar Hall, where he would be accompanied by 3 other trusted friends of his, one being my father, the other was Professor M.K. Sanu, and the other was Dr. C.K. Ramchandran. We used to call them the Travancore Cochin Literary, Scientific and Charitable Group, which was basically a play on the words of the regulatory statute which goes by the same name. Professor Sanu was, of course, the literary component of it. Dr. Ramchandran was the scientific component. And both Justice Krishna Iyer and my father had a very charitable disposition, so that went well as well. Now, among other things, what I noticed, and which is quite hilarious, is that they would have these perambulations around the Darbar Hall ground. And for those of you who are in Cochin, you know that just opposite Darbar Hall ground there is the TDM Hall. And to the right you have the Bharat Hotel, and to the left you have the Ram Verma Club. And all these are venues for functions of different hues and colors. There have been many, many instances where while these fine gentlemen of the law and science were taking their perambulations, you would find people coming in distress. And those were people who were supposed to have chief guests coming for their respective functions in some of these venues. And those chief guests would have ditched them in the last minute. They would have cancelled. And so suddenly the hunt was on for a chief guest. And they would come rushing into the Darbar Hall ground. I've seen this myself. And they would all beg Justice Krishna Iyer, "Sir, our chief guest has not come. Can you please come?" But there was only one condition for Justice Krishna Iyer. He would readily oblige. He said the chief guest would come only not as an individual, but they would come as a package. So you had 4 chief guests who had to go for these functions. And once you went there, it required just about 3 minutes for Justice Krishna Iyer to find out what the theme of this function was, that all 4 of them had been thrust with. So he would go there and in 3 minutes he would gauge the audience, he would gauge the theme, and then, just like what we just saw here, for another 40 minutes he would just go on and on about any subject. 40 minutes of exposition, deep knowledge of the subject. This was what Justice Krishna Iyer was, and this is why I said Justice Nariman's talk today is the most befitting tribute that you can pay to the man. The other aspect that really struck me about Justice Krishna Iyer, always has, is his plain simplicity and his clear thinking process. You never saw him wear fancy attire. He would not come in fancy cars. He had his khadi white kurta and dhoti and an abundant, bountiful supply of jurisprudence. This is what he went around with. And it is with those that he would attract the crowds that thronged around him just to hear his words of wisdom. This was the man. And it's not as though simplicity percolated only his personality. his jurisprudence was also very simple. It was simple, but it was humanistic, as he liked to call it. It was humanistic in its vision. And why was it humanistic? Because it had the human touch. In a society which was so obsessed with rights, Justice Krishna Iyer spoke in the language of duties. And if you ask me, because you cannot go through the entire, he's written about 700 odd judgments. If you go through each of those judgments, the single common thread that you find running through those judgments is this duty-based jurisprudence. Take any of those cases that have become landmark cases, say the Mumbai Kamgar cases where you're talking about industrial jurisprudence, you're talking about the rights of workers. His focus was entirely on the duties of the employer to his employees. What happened in Maneka Gandhi? Everybody talks about Maneka Gandhi. Many people say Maneka Gandhi is only rhetoric, and the law was already laid down in R.C. Cooper. But when Justice Krishna Iyer spoke through his opinions, he was talking about the state's obligations, the state's duty to ensure that through the procedural justice, through procedural provisions, the dignity of the individual is respected. And then, of course, you have the famous Ratlam municipality. In Ratlam municipality, he exhorted the municipalities, the state, to respect the rights of the citizens to a clean environment. And he went further and he said, when it comes to protection of fundamental rights of citizens, the state cannot plead financial paucity of funds. It was not something that the state could plead to escape from its bounden duty to protect fundamental rights. And then, of course, we have the famous N.M. Thomas case, which was more relevant to the topic of discussion today. And in N.M. Thomas, both Justice Krishna Iyer and Justice K.K. Matthew, another illustrious son of our soil, who has another illustrious son in our own Justice K.M. Joseph, who's sitting silently in this crowd. Both of them breathed into these provisions, the constitutional provisions, the fundamental idea that the equality doctrine, which you find in Article 15.1 and 16.1, 15.4 and 16.4 are not actually exceptions to the rule. They're actually furtherance of the principle of equality that you find enshrined in 15.1 and 16.1. So stop viewing these as exceptions, see them as affirmative actions. And that, he said, to quote Justice Krishna Iyer himself, equality under the Constitution was not mere formal equality, but substantive equality that could only be attained by implementing positive discrimination through affirmative action so as to compensate for existing inequalities. When it came to judging, and he was talking about how judges should behave in courts when they're actually deciding cases. Law to him was not something that you used for dispensing justice. It was not a tool for dispensing justice. Judges had a very important role to play in society for him. Judges were basically social engineers. They had to use the law to tweak, to mold society, to change the thinking in society. And that was the job of a judge. And he said, it's a sacred duty, and I'm quoting him, it's a sacred duty and not a mechanical application of laws. And for those of you who've read Jolly Varghese case, 1980s, where you were confronted with a case where a person was actually threatened with incarceration for no fault except that he did not have the money to satisfy a decretal debt. Now, under the provisions of the CPC, you have a provision there which says that one of the modes of execution is by putting the debtor, if he's not paying up, you put the debtor in jail. And that was most abhorrent for Justice Iyer. He said, how can you have, and I don't want to paraphrase what he says because those words which he uses are so pregnant with meaning. He says, to be poor in this land of poverty is no crime. And to recover debts by the procedure of putting one in prison is flagrantly violative of Article 21 of our Constitution. Just in that one sentence which is so pregnant with meaning. And that, I think, is what judges of today, all of us, need to imbibe the methodology of conveying a duty-based jurisprudence through crisp, meaningful sentences. How then do we uphold this legacy of Justice Iyer? What is it that we need to do? Well, I do believe that as integral members of the legal fraternity, we need to ask ourselves one basic question, and that is, must this obsession with legal rights continue to pervade our jurisprudence? Can we not think in terms of duties? Can we not change our perspective? Can we not be a society which is more duty conscious than rights charged? And I think it's important that in the backdrop of the turmoils that we see in society today, we introspect on this particular subject and come out with a formula, come out with a scheme that will actually uphold our constitutional ideals. And I do hope, finally, that these commemoration lectures will at least serve to periodically remind us of the need to uphold the true spirit of our constitutional text. Ladies and gentlemen, I thank you for your time. Jai Hind.
As a token of our heartfelt appreciation and gratitude, we'll be presenting mementos to the honorable dignitaries. I invite Justice K. Ramakrishnan, former Judge, High Court of Kerala, and member, Board of Trustees, Sharada Krishna Sadgamaya Foundation, to present a memento to Honorable Mr. Justice Rohinton Nariman as a mark of our respect and gratitude. I invite Advocate P.B. Sahasranaman, Vice President of the Foundation, to present a memento to Honorable Mr. Justice Nitin Jamdar as a token of our heartfelt appreciation. I invite Senior Advocate B.B. Siddharthan, Vice President of the Foundation, to present a memento to Honorable Mr. Justice A.K. Jayashankaran Nambiar as a token of our heartfelt appreciation and gratitude. Now, we move on to the most awaited event of the ceremony, distribution of merit awards to the first rank holders of LLB and LLM from 7 law universities in Kerala. May I request Honorable Mr. Justice Rohinton F. Nariman to distribute the award to the award winners. First, we'll be calling upon the rank holders in the LLM category. I request all the award winners to kindly assemble near the auditorium, near the stage. The distribution of awards in the LLM category will be happening first. I invite Devika T.S., first rank holder from Mahatma Gandhi University for the year 2023. Devika Dilip from Mahatma Gandhi University for the year 2021 to 23. Ali Moon from Mahatma Gandhi University for the year 2021-2023. Ammu S from Mahatma Gandhi University for the year 2021-23. Reenu S. Babu from Mahatma Gandhi University for the years 2021 to 2023. Aishwarya S. from University of Calicut 2022 to 2024. Elizabeth KJ from National University of Advanced Legal Studies for the years 2023 to 2024. Lumina L from National University of Advanced Legal Studies from 2023 to 2024. Ria Raymol Ipe from Central University of Kerala from 2022 to 2024. Sandhya S from University of Kerala, years 2023 to 2024. Parvati S from Cochin University of Science and Technology for the year 2022 to 2024. Nandana Rajesh from Cochin University of Science and Technology for the years 2022 to 2024. Next up, we have the Merit Award winners from the LLB category. Anakha K. Iyer from Mahatma Gandhi University in BBA LLB course honors for the year 2023 to 2024. Gauri M from Mahatma Gandhi University, BA LLB honors 2018 to 2023. Hima Harikumar from Mahatma Gandhi University, BCom LLB honors 2018 to 2023. Varsha S from Mahatma Gandhi University, BBA LLB honors 2018 to 2023. Liz Joni from Mahatma Gandhi University, LLB Unitary 2023 to 2024. Anjali M from University of Calicut, LLB Unitary, years 2023 to 2024. Varnana Valsan from University of Calicut, BBA LLB honors for the years 2023 to 2024. Maisoon Saifuddin from University of Calicut, BBA LLB honors 2019 to 2024. Next up is Tania Nathansi from Kannur University, BA LLB 2023-2024. She is visually impaired and she has completed her legal studies from Kannur University using Braille system and assisted screen reading technology. A big round of applause for Tania. Sneha TS from National University of Advanced Legal Studies, BA LLB Honours 2019 to 2024. Satya G. Krishnan from Cochin University of Science and Technology, BBA LLB Honours 2019 to 2024. Anakhapi from Cochin University of Science and Technology, BCom LLB Honours 2019 to 2024. Sankeet CS, Cochin University of Science and Technology, LLB for the year 2023. Alfina Ibrahim from University of Kerala, LLB Unitary 2021-2024. Sucharita B from University of Kerala, BCom LLB 2019-2024. Arya MA from University of Kerala, BA LLB 2023-2024. And the last one, Aparna A, University of Kerala, BBA LLB for the years 2019 and 2024. Thank you, sir. We have come to the end of the distribution ceremony. Now, I invite Advocate Sanand Ramakrishnan, Secretary, Sharada Krishna Sadgamaya Foundation for Law and Justice, for the vote of thanks.
Distinguished guests, on and off the days, ladies and gentlemen, the Board of Trustees and the members of the Foundation offer their profound gratitude to Honorable Chief Justice of the High Court of Kerala, Honorable Mr. Nitin Jamdar, Justice Nitin Jamdar, for his gracious presence and for presiding over the function. I wholeheartedly concur with the sentiments and observations expressed by our President, K. Balakrishnan Iyer, in his welcome address about Chief Justice Nitin Jamdar. The articulation is precise, requiring no further elaboration. Every word conveys our deepest respect. On behalf of the Foundation and all those assembled here, we express our deepest gratitude to you for presiding over this function, despite your hectic schedule. Thank you, sir. Awestruck, as Justice Jayashankaran Nambiar put it, is the word that comes to our minds after listening to Justice Nariman's brilliant, analytical, meticulous, and impeccable exposition. On behalf of the Board of Trustees and members of the Foundation and the wonderful audience gathered here, we offer our deepest gratitude and thanks to Justice Nariman for delivering the 10th Justice V.R. Krishna Memorial Law Lecture. As we all know, Justice Nariman is a towering intellectual genius, a brilliant jurist and thinker with extraordinary depth and remarkable compassion. He is renowned for his profound insights and deep knowledge, not only of law, but also an entire spectrum of complex subjects, including history, comparative constitutions, religion, Western classical music, and so on, all of which is beautifully in sync with the legendary personality of Justice V.R. Krishna. Therefore, we feel that it is truly befitting that today we are witnessing one towering intellectual genius commemorate another. Thank you, sir. It is truly an honor for all of us present here. On behalf of the Board of Trustees and members of the Foundation, we express our deepest thanks and gratitude to Honorable Dr. Justice A.K. Jayashankaran Nambiar for graciously delivering the commemoration address with characteristic flair. It is most befitting for us to have Justice Jayashankaran Nambiar join us in commemorating this illustrious luminary, as he was closely associated with Justice V.R. Krishna through his much revered father, late Justice K. Iyer. Sir, your address today was truly inspiring as you shared personal anecdotes referring to Justice Iyer, mostly from your own interactions. Thank you, sir. A special word of thanks and deepest gratitude is due to Honorable Registrar General of the High Court, Public Relations Officer, Shri T.S. Arun, Shri Ashok, Protocol Officer, and Shri Robin, IT Cell in charge, for their wholehearted cooperation, without which this function could not have taken place smoothly. I also thank the members of the Board of Trustees, particularly Justice T.V. Ramakrishnan, Chief Patron, Justice K. Balakrishnan Nair, President, our patron, Justice K.M. Joseph, sir, is sitting in the audience, and Vice Presidents, Sri P.V. Sahasranaman, sir, and Sri V.V. Siddharthan, Senior Advocate, Justice K. Ramakrishnan, Sri R. Lakshmi Narayan, I. Sheila Devi, Sri P.S. Anthony, Retired District Judge, and Srimati Chandrika Arvindakshan. Your wholehearted efforts have been instrumental in the seamless organization of today's function. Behind every edition of this memorial lecture we hold year after year, it is important for us to highlight the remarkable hard work and dedication of our small team of young volunteers, without whose dedicated efforts this function would not be what it is. Our deepest appreciation to Advocate Govind, Advocate Krishna, who compared the event, Advocate Tasmi Taj, Advocate Anjana Kannat, Advocate Atira, who beautifully coordinated the stage activities, Advocate Fatima, who mellifluously sung the prayer, for their commendable efforts in ensuring the success of today's program. We sincerely and warmly thank all esteemed members of the legal fraternity, current and former judges of this court, senior advocates, president and office bearers of the Kerala High Court Advocates Association, advocates, retired judicial officers and staff of this court, friends from the media, LiveLaw, students and their family members for your presence today. Thank you.
Before we bid adieu, there's a small group photo session with the honorable dignitaries. May I invite all the award winners from the LLM category to kindly come onto the stage for a group photo session with the dignitaries. I also request the award winners in the LLB category to get ready for their photo session, which would happen subsequently. We have on stage the award winners of the LLM category. Next up, we have the award winners from the LLB category on stage for the group photo session. for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगल जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय